Hi, my name is Zishen. Today, me and my member will be discussing about Sri Hijaz Berhad financial collapse, which raises 4 key issues under Malaysian company and insolvency law. First, the validity, priority, and legal effect of the company fixed and floating charges must be assessed. Second, the director's duties and potential liability in the vicinity of insolvency require evaluation. Third, the right and priority status of employees as preferential creditors must be determined. Finally, the implication of separate legal personality, including the extent to which it shields directors and shareholders unless where statutory exceptions apply, must also be clarified. Our following analysis will focus on question 1 and 2 issued together, which we will examine the distinction between fixed and floating charges, registration requirement, crystallization, and the effect of negative pledge clause before determining the creditor's priority ranking. A fixed charge is a proprietary security interest that attaches immediately upon creation to a specific identifiable asset. Because it is asset-specific, the company cannot dispose of the charged asset without the lender's consent. This control-based test mirrors English authority, notably AGNU against IRC and Risk Spectrum Plus, which held that the classification of a charge depends not on its label, but on whether the charger retains freedom to deal with the charged asset. Academic commentaries strongly support this position. William Day, writing in his article Fixed and Floating Charges, A Question of Consent or Control, argues that the true dividing line in the degree of control retained by the chargee. If the charger cannot dispose of the asset without consent, the charge is fixed, even if described otherwise. Good, in his insolvency treatise, similarly emphasized that a fixed charge confers immediate proprietary control and restricts the charges dealing with the asset. Lightman and Moss adopt the same view in their work on administrators and liquidators, stressing that the fixed charge is characterized by immediacy, attachment, and the charge's negative control over disposition. A floating charge, by contrast, covers a shifting pool of assets, typically the circulating capital of the business, and allows the company to deal with those assets in the ordinary course of business. The classic judicial formulation in Evans against rival granite quarries describe a floating charge as hovering over a changing class of assets until an event-triggered crystallization. Malaysian courts have fully adopted this description, particularly in UMBC against official receiver of Sun Hap Seng. Alice Ferran, in her article Floating Charges, The Nature of the Security, observed that a floating charge is a present security but intentionally structured to provide commercial flexibility until crystallization. The English case Re Bright Life and Risk Spectrum Plus offer further insight. Re Bright Life is often cited to demonstrate that parties may attempt to define the scope of their charge by drafting, but this drafting cannot override the fundamental question of control. Risk Spectrum Plus further confirms that the classification is determined by the substance of the arrangement, not its form. Both cases reinforce the doctrinal position that only the presence or absence of control can distinguish a fixed charge from a floating charge. The distinction between fixed and floating charges carries significant consequences for priority in insolvency. A fixed charge generally ranks above a floating charge regardless of when the floating charge crystallizes. This rule is well established in English law as illustrated in Re Benjamin Cobb and Sons, and is mirrored in Malaysian insolvency practice. Philip Wood, writing in the Cambridge Law Journal, explained that the structural subordination of floating charges is essential to protect preferential creditors and maintain certainty in credit market. The Insolvency Act framework reinforced this as assets subject to a floating charge are made available to preferential creditors, whereas assets under a fixed charge are not. Academic commentary, including Good, Wood, and Ferran, emphasizes that this hierarchy preserves predictability in commercial transactions. Floating charges act as a secondary layer of security that yields to fixed charges. The only situation in which registration dates for floating charges become decisive is where two floating charges compete with one another. Thus, in principle, a fixed charge will outrank a floating charge. However, before applying this priority rule, one must consider whether the charge is valid and enforceable, which depends on compliance with registration requirements.
Before comparing the priority between the creditors, it is essential to determine whether the charges have been validly registered. Under Malaysian law, registration is a decisive factor because a charge only operates as a proprietary security in insolvency if it's duly registered. Under Section 352 Sub 1, every company charge must be lodged with the registrar within 30 days using the prescribed statement of particulars. According to Section 353 Sub E, charges over land, such as those granted to Amanah Bank and Maju Credit, fall squarely within the categories requiring registration. Once registered, it gives constructive notice under Section 39 of Companies Act 2016, except for the instrument itself, placing the burden on later creditors to check the register. This was confirmed in the case of KL Engineering and Arab Malaysian Finance. Registration provides conclusive evidence of the charge and secures priority over the liquidator, unsecured creditors, and later charges. Malaysian courts, such as in UMBC and Alumnex, treat registration as conferring open and actual knowledge. By virtue of Section 352 sub 1, priority is determined by the date of registration, not creation. This is also relevant as Sri Hijau created and registered several charges with different parties. Failure to register has serious consequences. Although an unregistered legal charge is equitable at general law, Section 352 sub 2 makes it void as a security. It is ineffective against the liquidator and creditors, and the chargee becomes unsecured. In Bangsa Sdn Bhd and Malayan Banking Berhad, the court reiterated that a charge is a security interest. Thus, failure to register strips the transaction of its secure status. As per Section 352 sub 3, the underlying debt remains enforceable, so the creditor may sue personally for repayment. Since the charge is unregistered, third parties are not deemed to know of it. This exposes the unregistered chargee to being displaced by later registered charges over the same property. The liquidator may therefore treat the property as unencumbered. If the 30-day period is missed, the chargee may apply for an extension under Section 361 where the failure was accidental, inadvertent, or otherwise justified, provided no prejudice is caused. Court approval is required for registration outside the 30-day window. Courts will not extend time after liquidation has commenced or where insolvency is imminent. If Amanah Bank's fixed charge was not registered and the directors knowingly failed to lodge it with SSM, under Section 352 sub 10, they could be fined up to 50,000 ringgit if the failure continues after the conviction and 500 ringgit per day for a continuing offence. Although registration does not itself make a negative pledge enforceable against third parties, constructive notice may arise if the restrictive clause appears in the prescribed particulars. Under Companies Act 2016, the registration form requires disclosure of whether the creation of subsequent charges is restricted. Courts and commentators note that this field of Item 7 is mandatory. Thus, if the negative pledge is accurately lodged, subsequent charges are deemed to have notice and must inspect the form. However, although a certificate is issued once a charge is registered, it does not conclusively reflect the charge's full terms. The actual security agreement remains the true evidence between the company and the charge holder. Third parties relying on the registration form are not bound by any unrecorded restrictive clauses, and if the particulars lodged are inaccurate through no fault of the registrar, the charge holder bears the risk. On the facts, Amanah Bank's fixed charge over office building on 1st of August 2018 was never registered. This is a breach of the registration requirement under Section 352 sub 1. Read with Section 353 procedures, they should have been registered under Section 352 sub 1 sub A because it is a charge on land. When they fail to do so, Section 352 sub 2 kicks in. Their security is void against the liquidator and any creditor. Therefore, Amanah Bank is treated as an unsecured creditor during winding up. They lose all priority even though their charge was created first in time. Because of non-registration, the office building becomes part of the general pool of assets for all creditors. Their rights are only contractual, not proprietary. Amanah Bank may attempt to salvage its fixed charge by applying for late registration under Section 361, which empowers the court to extend time where the failure to register was accidental due to inadvertence or where it would be just and equitable to allow registration. If granted, the charge may regain its proprietary effect and potentially rank before Kaya Finance and Maju Credit. However, Malaysian courts are generally reluctant to grant such applications once insolvency is impending, as this would prejudice other creditors. The long delay from 2018 to winding up also suggests negligence rather than inadvertence. Therefore, while it offers a theoretical lifeline, the likelihood of success on these facts is minimal.
I will present the crystallization of floating charge, the role of negative place clause, and how this concept apply to our scenario. I will also integrate insightful two key journal articles to strengthen the analysis. What is crystallization? Crystallization occurs when a floating charge becomes fixed, immediately attaching to the company assets and removing the company flexibility to deal with those assets in the ordinary course of business. Automatic crystallization occurs without notice when a specific triggering event happens, such as the appointment of a reserver. In Silverstone Marketing Sdn Bhd and Hok Van Him Trading Sdn Bhd and others, the court confirmed that crystallization can occur in two ways, which is the automatically upon a specific event, requiring no action by the charge holder and by affirmative steps such as issuing a notice. In Silverstone, the automatic crystallization applied, so the floating charge immediately became a fixed charge once the event occurred, giving the debenture holder priority over the company's assets. According to the recent journal article, especially in the crystallization of floating charge, rethinking the conceptual framework in modern commercial practice, lenders often use automatic crystallization clause because they need a security mechanism that reacts immediately when the company is in financial trouble. This is shown that crystallization is not just a technical rule but a practical tool to stop the company asset from being lost. So when does the crystallization actually happen? There are a few common situations where this happens. First, when a company defaults on a loan. A good example in NGV Technology and Keraja, Malaysia, the company fails to repay its loan, so Maybank issue a crystallization notice and appoint a reserver. Then default triggered the crystallization. Second, crystallization occurs when the company breached the charge agreement, such as by creating new charge or overborrowing. Negative pledge clause stop the company from giving others security over the same assets. Third, if the assets lose value quickly, the lender might crystallize the charge or protect itself. This shows a weakness of floating charges as the company can use the asset freely until crystallization happens. Fourth, when others creditors start enforcing their rights. In Evans and Ryman, Granny Couriers Limited Company, the court said a judgment creditor might actually get priority unless the floating charge crystallized first, so enforcement action by others can trigger crystallization too. And finally, when the company enters winding out, we can refer to the case of Theo Vincent and True Creations neighborhood, where filing a winding out petition had some effect. So overall, crystallization happens at these key moments of financial stress. Sri Hijau debenture includes a negative pledge clause which prohibits the company from creating further charge ranking ahead of the lender. The journal article, The Negative Pledge as a Security Device, highlights an important point, which is that a negative pledge resembles a form of security interest, but is entirely contractual. It does not create any priority rights that can automatically by third parties. The article highlights that negative pledge are effective only if later creditors have actual or contractual notice. If a successor creditor is unaware of the negative pledge, their fixed charge can still take priority even though the company breached the clause. This conceptual understanding is crucial when assessing the conflicts between Kaya Finance and Maju Credit. Although Section 39 of the Company Act 2016 had abolished the doctrine of constructive notice for company document, it excludes the instrument of charge. Applying this to our case, when Maju Credit grants the charge, they should have examined the form as been aware of the content and note that there is a negative pledge clause included in Kaya Finance charge. Therefore, Maju Credit's subsequent fixed charge will not take priority over any negative pledge clause in Kaya Finance floating charge. In our scenario, Kaya Finance holds a fixed charge over of Sri Hijau assets as the company has defaulted and is about to enter winding up, so the conditions for crystallization are clearly met. Applying the scholarly framework, Kaya floating charge will crystallize automatically if the debenture includes an automatic crystallization clause. This aligns with modern commercial practice as highlighted in the first journal article. Once crystallized, Kaya charge becomes fixed and grant priority over any uncrystallized floating charge. Regarding the negative pledge, consistent with the second journal article, the clause gives Kaya a strong contractual right against the company. So in effect, Kaya Finance is well protected because crystallization secured its position and its priority stayed ahead of Maju Credit due to the notice rules surrounding negative pledge clause.
Having applied the relevant legal principles to the facts, the final priority ranking among the three creditors cannot be determined with certainty. Kaya Finance, ranked first as its floating charge having been duly registered, crystallizes upon the commencement of liquidation. Once crystallized, the charge transforms into a fixed charge attaching to the assets then in existence. Although crystallization does not grant retrospective priority, in this case, Kaya's charge is the earliest valid and enforceable proprietary security among the creditors. This places Kaya at the top of the priority structure. Maju Credit ranks second. While Maju hold a registered fixed charge over the Nilai factory land, the charge was created after Kaya's floating charge and therefore remains subordinate to Kaya crystallized interest. The fixed nature of Maju security gives it strong proprietary protection, but it cannot override an earlier floating charge that has crystallized at the point of liquidation. Amanah Bank ranks last, which is the third. Although Amanah received a fixed charge over the Shah Alam building, the failure to register it under Section 352 Sub 2 of the Company Act 2016 rendered the charge void against the liquidator. Without registration, the charge loses its proprietary character entirely, leaving Amanah to participate only as an unsecured creditor. In conclusion, the correct priority ranking upon liquidation is first, Kaya Finance, second, Maju Credit, and third, Amanah as an unsecured creditor.
In determining the rights of the employees during insolvency, the primary consideration is the statutory rejoin based on the categorization of creditors in Chai Hap Seng Sendirian Berhad and Ketua Pengarah Hasil Dalam Negeri, where the court ruled that sales proceeds received from the disposal of the land which are charged ought to be utilized in the order of priority of secured debt, preferential debts under Section 527 Sub 1 of the Companies Act 2016, and unsecured debts. So the application of creditor priority rule under Section 527 Sub 1 is illustrated in Malaysian Trustee Berhad and Transmile Group Berhad, where the court rejected the appellant's application to claim priority over other unsecured creditors based on the contractual subordination provision, as they were not parties to the trust deed, and the unencumbered assets is to be paid according to the order of priority under Section 527 Sub 1 Sub A to Sub 1 Sub F. Upon the payment of preferential debts, the remaining assets will be paid to the unsecured creditors, and all debts are to be paid subject to the principle of pari passu. Pari passu denotes that all persons similarly situated are entitled to equality in treatment in the distribution of assets of the company in the process of liquidation, where debts of the same class shall rank equally between themselves and shall be paid in full, unless the property of the company is insufficient to meet them, in which case they shall abate in equal proportions between themselves. The distinction between secured and unsecured creditors significantly impacts their rights and potential outcomes in case of a borrower's default. Secured creditors have a stronger position with specific assets backing their claims, giving them more certainty in recovering their funds. Unsecured creditors lacking this security face greater risk and receive lower priority in debt repayment. Particular to the facts, under Section 527 Sub 1 Sub B, employees are entitled to unpaid wages or salary for up to 4 months before the company's running up. This includes any parts of their pay earned through commission, allowances or reimbursement under their employment contract, and is claimable up to 15,000 ringgit per employee. Under Section 527 Sub 1 Sub E, any due payment of Social Security, Employee Provident Fund or retirement benefits plans is payable within 12 months before the commencement of running up. Furthermore, in the event of running up, employees are treated as terminated from their employment and are therefore entitled to termination benefits. So, apart of unpaid wages and compensation, employees are entitled to claim indemnity in lieu of notice under Section 12, Subsection 2 of Employment Act 1955 and termination benefits under Regulation 6 of the Employment Termination and Layoff Benefits Regulations 1980. After the full payment of secured debt is paid, Sri Hijrah is advised to repay the salaries due up to 4 months before the running up with the limit of 15,000 ringgit per employee, and unpaid APF, termination benefit for employees who fulfills the criteria, and the indemnity in lieu of notice if the statutory or contractual period is breached before the unencumbered assets are to be distributed to the unsecured creditors. In the event that the assets are insufficient, they are to be distributed equally among the creditors of the same class. In the journal titled Takaful as a Mechanism for Protecting Unsecured Creditors, Legal and Operational Consideration in Malaysia, Suruhan Jaya Syarikat Malaysia and the Malaysia Department of Insolvency suggest that the current winding up legislation inadequately protects unsecured creditors' right for relegating unsecured creditors to the end of the asset distribution queue, causing substantial losses to smaller creditors and deter unsecured lending. It is proposed that a comprehensive legal review is required to better align Malaysia's insolvency laws with international best practices such as insolvency scheme under Section 176 Capital A of the UK's Insolvency Act 1986. The Act requires setting aside a portion of funds from assets secured by a floating charge up to the current cap of £800,000, which is exclusively claimable only by unsecured creditors. Secondly, the government could empower the implementation of mandatory credit insurance or establish a guarantee fund which functions analogously to deposit insurance for bank clients to provide compensation in corporate insolvency cases. Lastly, Takaful Indemnity Scheme, where participating companies voluntarily contribute part of their profits or capital into the Waqf Fund under the principle of Tabaru. The fund is managed by Takaful operator to be reinvested in a Sharia-compliant and low-risk instrument to preserve the capital and earmarked to compensate unsecured creditors, providing a financial safety net for companies incapable of covering their debts. While the mechanism seems promising, a further compliance of Islamic Financial Services Act 2013 and the Takaful Operational Framework 2019 is required for further alignment and legal integration.
Moving to question 4. The issue is whether the doctrine of separate legal personalities should Sri Hijau directors and shareholders from personal liability. In what situation that quotation may be removed? The doctrine of separate legal personality is the cornerstone of company law. Under Section 18 Sub 1, Companies Act 2016, a company becomes a legal entity upon incorporation, and Section 20 further provides that it becomes a body corporate with a personality separate from its member. This means that the company can own property, enter into the contract, sue and be sued in its own name. The principle was famously established in Salomon and Salomon case, where the House of Lords held that a duly incorporated company is a legal person distinct from its shareholder. Lord Manhattan said the company is at law a different person altogether from the subscribers. The business may be the same, and the same persons may receive the profit. Yet in law, the company is not the agent or trustee of the subscribers. The Privy Council reaffirmed this in Lee and Lee Air Farming case. An individual can be both the controlling shareholder and managing director of the company, as the company and its controller are legally distinct entities. Salomon established the concept of limited liability, meaning shareholders are liable only up to amount they invested. As the article in the Law Review notes, the whole point of forming a limited company is that shareholders can manage business without incurring the risk of unlimited liability for the company debts. Applying this principle, the debts and liabilities of Sri Hijau belong to the company itself, not to its directors or shareholders. Therefore, even though the company is unable to pay its debt and fast wheeling up, the directors are not personally liable for repayment of the company's loans to Amana Bank, Kaya Finance, or Microcredit. The liability remains limited unless exceptional circumstances justify lifting the corporate view or imposing statutory liability. Courts may lift or pierce the corporate view where the company form is used to evade obligation or commit wrongdoing. A key starting point is Guilford Motor and Horn, where the company was incorporated as a sham to avoid a non-competition clause. The court therefore lifted the view. Similarly, in the Jones and Lehman, the defendants attempt to avoid specific performance of a contract for the sale of land by transferring the property to the company he controlled. The court found that the company was a device to evade contractual obligation and lifted the corporate view. Lifting the view of incorporation has also been followed in Malaysia. In Asmatra Sedera Berhad and Bank Bumiputera Malaysia Berhad, the Supreme Court held that the corporate view may be lifted, particularly when an element of fraud is involved. In the recent federal court decisions of Gurpachan Singh and Velasamy Penusamy, affirmed that the corporate view may be lifted where a corporation is used for a fraudulent purpose. To avoid assisting obligation or to abuse the corporate legal personality, the court explained that fraudulent purpose include actual fraud or fraud in equity, which arise where separate personalities of company being used to evade contractual obligation. In such cases, the court will disregard the notional separateness of the companies. However, the corporate view is not absolute. More recently, the Federal Court in Solid Investment and Alcatel Lucent overturns the decision of the Court of Appeal because there was no evidence of fraud. The court stressed that actual fraud or fraud in equity is required. In the latest 2019 decisions of Chadwin's Properties and Zookeeper case, the Court of Appeal held that piercing the corporate view is only appropriate in special situations where the company is used as a facade. Mere control of the company by the intended defendants is insufficient. In another latest Court of Appeal case, Ong Leong Chiu and others case held that corporate view could be lifted for a deliberate evasion of a contractual or fiduciary obligation. This followed Tenaga Nasional Berhad case, where the court reaffirmed that the corporate view could be lifted in exceptional situations involving actual or equitable fraud are required, and the use of a company as a facade to conceal the truth of facts. Beyond the common law, statutory exceptions under the Companies Act 2016 also impose personal liability on directors. Fraudulent trading under Section 540 Sub 1 holds officer personally responsible where business is carried on with intent to defraud creditors. Section 539 Sub 3 imposes liability for wrongful trading where directors incur debts with no reasonable prospect of repayment. Under Section 131, directors authorizing dividends out of capital may be personally liable. These provisions illustrate that limited liability is not absolute and echo similar protection in the UK under Section 213 and 214 Insolvency Act 1986. On the facts, there is no evidence that Sri Hijau Berhad directors acted dishonestly, traded with the intent to defraud, incur debts recklessly, or use the company as a sham to evade obligation. The company's insolvency appears genuine. The statutory triggers under Section 539 and 540 Companies Act 2016 are not met, and none of the common law lifted view grounds apply. Thus, the corporate view remains intact and the directors and shareholders retain full protection. Under the doctrine of separate legal personality, Sri Hijau Berhad alone is liable for its debts. To conclude, Malaysian law provides a clear framework governing creditor, priorities, and director obligation during insolvency. Charge ranking depends on the nature, timing, and registration of each security, where the directors must avoid conduct that breaches statutory duties. Employees hold preferential protection for unpaid wage and the doctrine of separate legal personality, shut directors and shareholders unless statutory or judicial exceptions apply. Together, this principle ensure a coherent and predictable outcome for Sri Hijau liquidation.